career.
All of them are career diplomats. And now this is why now, and I'm reading it, my lord, with section 156, that is of the Amendment Act, my lord. 156 now tells us what should happen, Lord, and
section 28 at 1520.
Yes, my lord.
So it refers to 163, not 156.
No, if we are at 15. Sorry, my lord. It's if we are 1520, my lord.
Yeah, that's what I'm saying. Which is section 28 of the 10th Amendment.
Yes, which is section 20. Yes, my lord.
Then it deletes 163.
That is so, my lord.
Of the first constitution.
Of the main constitution, if I may call it that way. Yes, my lord. So that there is a moratorium, my lord. That is placed. In other words, insofar as the career diplomats and attaches are concerned, the legislature, by design and in its wisdom, has said we move away from the standard practice, operating practice, as encapsulated in the Public Service Act and its regulations. We want now to regulate it through a separate act. It will define, but in the meantime,
how is it going to define, Mr. Letsika? Because in terms of one section 143B,
yes, madam.
This constitution says appointment and recall of career diplomats and attaches to foreign service shall be provided by an act of parliament.
Yes, it will not.
Why do you need an act of parliament when the constitution itself says the king is the appointing authority?
But remember, my lord, the king is the appointing authority insofar as the high commissioners are concerned, not the specialized staff, career diplomats. I presume one may say what they, if I may submit, they contemplated the professionals below the political cadre. I may be wrong on this one, but as I made, my lord, what they had in mind by career diplomats, these are professionals, military attaches, people who are involved in trade matters, because you have to have those in foreign service for the benefit of the country. So an act of parliament.
So those would be public servants.
Those would be public servants.
Yeah.
So an act of parliament would then have to get into play, like the Public Service Act, define qualifications, define the appointing authority, define experiences, define the terms and conditions of service, and so on, my lord. As we know them. So the section 156 has said, and I want to start on page 519, which is section 27 of the 10th Amendment. It reads as follows, and this is where the moratorium comes in, which we submit that this 10th Constitution brought in the moratorium insofar as the foreign service diplomats are concerned. It reads as follows: matters that have to be provided for by an act of parliament, and any matter that has to be implemented to bring into effect the provisions of this Constitution shall immediately after the coming into operation of this Constitution be prescribed or implemented by a responsible authority within a period of 18 months. If at the expiry of 18 months period referred to in subsection 3, there is any matter that is incomplete, Parliament may extend the period of 18 months for a further term of 18 months. And of course, subsection 3B and the following subsections. My lord, I submit, what does, in other words, it says, remember 143, my lord, says, an act of parliament will provide for the appointment and recall of this professional staff.
And why should that act of parliament be?
It should do it within a period of 18 months. In other words,
there's a hiatus now.
Exactly. There is a moratorium. I want to use the there is a moratorium. In other words, Parliament says until that happens. In other words, until an act of Parliament is enacted to regulate the appointment, the recall of professional staff. This staff contemplated in section 143B 6. Then, for the period of 18 months, there is a moratorium. And during that period, I submit, my Lord, Parliament, the legislature in its wisdom, expected that because there is a winter period, nobody would do anything. Nobody would purport to exercise the powers to appoint, the powers to recall any member posted in foreign service. Because the Parliament in its wisdom has said, I put a moratorium unless and until I would have enacted a new law which deals with, and I don't want to go in seconds, with the appointment and recall of these career diplomats and attaches. Absent such law, and within a period of 18 months, we submit, my Lord, that the first respondent or the respondents cannot purport to exercise such powers. They cannot purport to recall people from foreign service. They cannot purport to appoint people on foreign service. What they should do is to facilitate for the enactment of the law, so that the law will deal with situations such as that is facing my client. We therefore submit, my Lord, that on that score, the applicant has made out a case for agency. In other words, the applicant, and remember, my Lord, the test is at the lower level, is prima facie. In other words, is there prima facie?
If I may interrupt, before you go to
yes,
you are construing section 27. I say it's a hiatus, you say no, it's a moratorium.
yes.
That moratorium is to enable an act of parliament to be in place.
That is so.
And you are saying parliament should legislate within 18 months.
Yes, of course there's an extension, proviso of an extension.
No, how can parliament itself? It makes a law which says we are bound to legislate in 18 months. Then it says we can extend it. What does it make sense?
When we started,
because then they themselves are saying, because you see the problem we are having in this jurisdiction, Mr. Letsika,
yes,
is that members of parliament don't take advantage of the private members' bill.
yes,
If the executive doesn't bring a bill, they can spend the whole year not making laws there.
that is so. And it has happened.
Yeah, you see, that's the problem that I'm having.
Yes,
Whereas members of parliament, Mr. Letsika, they are there to legislate.
I agree.
And if you recall the Ambrosini judgment
Yes,
in South Africa of the Constitutional Court,
yes,
in fact they say a member does not even need the permission of parliament.
yes,
Because his primary duty is to legislate.
Is to legislate.
So you are not going to say, I'm waiting for a minister to bring a bill. You should actually be proactive, bring bills.
yes.
Yeah.
And
You
then
understand? Because in
according-
any event, that's your duty.
Yes.
Now, coming back to what you are saying in paragraph 27,
yes,
as I understand it, it says matters that have to be provided for by an act of parliament and have to be implemented to bring into effect the provisions of this constitution.
yes,
They are not even saying this act, this amendment act. They are saying this constitution. Because I think they are assuming, that's why I get confused. When they say this constitution, are they saying this constitution that they have made in the 10th amendment or the main constitution?
I will submit, my Lord, that we have to read the two constitutions, and I'm using the word two constitution advisedly, my Lord. I'll assume they complement each other. The understanding was that this is an amendment, an amending act, which is intended to amend the main constitution, and they complement each other. I submit.
Yeah.
I'm sorry to interrupt
Then
you.
they have to pass a law within 18 months
Yes, madam.
to give effect to the provisions,
Yes.
providing for a career
Diplomat and attaché. In other words,
career foreign service.
yes,
They have to provide for
they
such a-
have to provide that
As
within
parliament.
18 months. Yes, madam.
Now, that's a transitional clause. So what are they saying? Are they saying before they pass the law, Parliament itself,
Yes.
the status quo remains?
Yeah, I submit, my lord, the clauses. I'll get to it and I'll make this submission and say that what is contemplated here is that before they make the law, the actual law, the status quo should remain. In other words, they want to ensure that everything is done professionally. I don't want to make an example of other institutions and probably create a problem for myself. But what is at fore and what is clear is that they contemplated that we are moving from the old order. We are moving into a new order. And in the new order, we intend to make laws that will regulate how things and affairs of the nation must be conducted. So because we are moving into a new order, where we'll define the appointing and recalling authorities by an act of parliament, then everything should be, and as I said, I would prefer to use the term moratorium, should be put on hold until there is an act of parliament. There might be an act of parliament next week, my lord, or even after next week, or even today.
But the constitution that they have made under 143, it says it already says the power to remove. The power to remove. Vests in the king in accordance with the advice of the Prime Minister.
Yes, ma'am.
Similarly, the power to appoint.
Yes.
Vests in the king.
Yes.
Acting on the advice of the Prime Minister.
Yes.
So as at August 13, when this amendment was gazetted,
Yes.
the power vests in the
key
and
of
the
the
Prime
advice of
Minister.
the Prime Minister.
Yeah.
Yeah.
You see. Now, if that is the case, then you go to section 28 at 1520, page 1520. You see?
Yes.
163.1. A person who before the coming into operation of this constitution holds an office established under this constitution shall continue to hold the office in terms of this constitution. Subject, of course, there are two provisos there, isn't it?
Yes, ma'am.
Yeah. Then 2 says, any person who under this constitution or any existing law would have been required to vacate his office at the expiration of any period shall within the period of 6 months of the coming to operation of this constitution vacate his or her office and may choose either to retire or continue to serve subject to appointments, blah, blah, blah. You understand this?
Yes, ma'am.
So,
And
not?
And if I may interrupt your lordship, if we go to page 1521, it now refers to this constitution and any other legislation. That's where now the Act of Parliament comes in.
But that act is not here now.
Yes.
My problem is that Parliament talks about an act, but it doesn't make the act itself. It says, no, we'll wait for 18 months.
Yes. And
we'll extend it ourselves if we haven't finished the
if we haven't done our job.
Yeah, but I'm saying, why is that within those 18 months, the power is already vested in the Prime Minister.
In the key, brother.
Acting on the advice of the Prime
Of
Minister.
the Prime Minister, yes.
So why can't the Prime Minister in the interim, while Parliament is still waiting to finish his job, appoint and remove?
My lord, I submit that the legislature by design put the moratorium, and that would be our second. As I said, that was our first argument, and I submit in the context of what your lordship is saying that insofar as and that appointment, if I may, my lord, let me start from here at the appointment on the advice of the Prime Minister and the appointment by the King,
1499.
1499. Thank you, my lord. This relates to heads of diplomatic missions. In other words, and heads of consular posts. These are as I said, the Constitution and so the Act, and that has always been the case, even under the Public Service Act. It used to draw a line between the heads of the diplomatic missions and the heads of consular posts, as opposed to career, and these are, if I may conclude that submission, these are political appointees, because we know the Prime Minister is a politician. So he would be appointing Mr. Letsika to be the head of a diplomatic mission in a particular country.
Even if he knows nothing.
Even if Mr. Letsika has never been,
yes, he belongs to the same party.
Exactly.
Then you'll say that person is a career diplomat.
No. This one is the head. In other words, this one is the head. But those ones who are below the head of the mission, these are the public servants.
No, I'm saying career diplomacy.
Yes.
Right from the diplomat.
Yeah, it has to be professional.
Yes, that's what I'm saying. It has to be professional.
Yes.
Because these are career. In other words, when you send someone to England, he should be able to speak the Queen's language.
Yes.
So that he's not embarrassed when there's a gathering.
Exactly.
Yeah.
Yes.
He should be fluent in English and be wise in international affairs.
And then
he should not always be saying, let me consult myself.
Exactly.
Something arises. No, I'm not going to take a position. I'm not going to vote. I want to consult myself.
Yes.
Then he's told, no, you vote this way.
Yeah. Or they say, we have decided if you don't vote this way, these are the consequences for your country.
Yeah, we are going to recall you.
Exactly. So that, my lord, I would draw, my lord, and I submit that this one relates to career heads of diplomatic missions. And of course, the issue would be, are they any different from the other diplomats? And I would say, well, the technically speaking, they are not. But the Act, the 10th Amendment has made a deliberate distinction between the heads of diplomatic missions and career diplomats.
No, not career. That's why I have a problem. They are all career diplomats. The fact that the Prime Minister advises the King.
Yes.
The assumption that the only reasonable interpretation is that those people should be qualified. The Prime Minister can't just say, King, appoint so and so. Even when that person doesn't qualify. He has been looking after donkeys and goats.
Yes, ma'am.
Then suddenly tomorrow, no, get into the aeroplane and go to India. No, it can't work that way.
Well, it has worked.
In other words, other nations will laugh at us.
Yeah.
Say, is this the best that they have in this world?
And that's exactly what this current constitution, this 10th Amendment, is trying to curb.
Yes.
It's trying to deal with.
Even the power to appoint under 173.
Yes.
To advise the King to appoint.
Yes.
He should appoint people who are professionals.
That's the expectation. And that's as far as
that's the law. Now it is the law now.
Yeah.
In the past it was an expectation.
Yes.
But now it is the law. In other words, someone can be challenged. An appointment can be challenged.
Yes.
This person doesn't qualify.
Yes.
He's not appointable.
He's not a career diplomat. And one of my potential clients can come before court and say, I'm a career diplomat because of these reasons.
Precisely.
Letsika is not a career diplomat for these reasons. Yeah. So
where I was, Mr. Letsika, was simply this: that if you read the transitional process,
yes, ma'am.
The Constitution it doesn't operate retroactive.
No, it does not.
It operates prospective.
Prospective, yes.
Now I'm saying as at August
2025. Yes, ma'am.
What is the effect? Does it not mean that all of them,
yes,
as we stand now,
Yes.
They are governed by the 10th Amendment.
As at that date, my lord, they are governed by the 10th Amendment. It is operational, it binds them.
Yeah.
Yeah.
But then you talk about Parliament saying, but we still have to pass a law.
Yes.
In 18 months.
That's
So
what
I'm saying then what should happen in the interim?
Then there should be a moratorium. As I said, I prefer that term. In other words,
What about if a diplomat misbehaves? Is he going to say you cannot discipline me in terms of 143?
yes.
Why? You have a delinquent, then he says, no, until Parliament passes a law, you are not going to touch me. Does it make sense?
No, it doesn't make logical sense.
So then it means the moratorium that you are talking about, Mr. Letsika,
It's subject to conditions, of course.
yes.
Yes.
It means that provided you behave well,
And
you are not
provided you meet the requirement.
you are not going to be recalled. But it doesn't mean that you are not going to be disciplined.
Yes. And it doesn't mean the wrong person should discipline you. In other words, it doesn't mean the Prime Minister can send Advocate XY to go and discipline you when the law, and these are matters, my lord, if I may. These are matters that are contemplated in 143B 5, that an act of parliament would be required. In other words, an act of parliament would deal with this finer and minute details of what should happen if this were to happen, if this man were to, or this woman were to be an embarrassment at the international space. This should happen, so and so will wield authority to discipline them, and so forth and so on.
Does this amendment repeal the existing legislation? That is the Foreign Service Regulations together with the Public Service Act?
It indirectly does, man. Because
where is it indirect?
It's indirect because in the past, my lord, I'm going to be referring to the regulations, my lord, the 2008.
I'm merely saying, let's look at the amendment first.
Yes.
You say it does not directly and expressly repeal existing laws. That's your submission.
Yes.
You see? And you're going to direct me to a section which supports your submission.
Yes, I will.
That proposition.
My lord, I want to draw your lordship's attention to I know the regulations have a chapter dealing specifically, if his lordship could bear with me for a second. Yes. There is a
because it can only be section 27.
Yes.
Only because it's the one that has the heading transitional and temporary provisions. That's amendment of Roman 50.
Yes. Yes.
Which amends 156 by deleting one
Subsection 3.
Maybe then, because you have the Constitution, the main one.
Yes.
Can you read to me what 156 1 and 2 provide?
One 156.
Yeah, 156. Sub 1s and 2. Because this one only.
Please bear with me, my lord. I'm at 156 of the original one.
Yeah.
Subject to the provisions of this Constitution, the existing laws shall continue in force and effect on and after the coming into operation of this Constitution, and then have effect as if they had been made in pursuance of this Constitution, but they shall be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with this Constitution. Then I'm going to do, I'm trying to capture all of it. Where any matter that falls to be prescribed or otherwise provided for under this Constitution by Parliament, or by any other person or authority is prescribed or provided for by or under any of the existing laws, including any amendment to any such law made under this section, that prescription or provision shall, as from the coming into operation of this Constitution, have effect with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring it into conformity with this Constitution, as if it had been made under this Constitution by Parliament, or as the case may be, by the other person or authority. And
yeah, well, it doesn't assist because they are talking about laws that were in place in 93 when we
yes,
exited from
when we moved from the old era to the new era,
to democracy.
to democracy. Yes, no.
Which means then we'll navigate by section 28.
Yes. I think that problem that we identified.
When it says existing public officers,
Yes.
public offices and institutions.
Yes, madam.
So 163.1 then says, the person who before the coming to operation of this Constitution holds an office established under this Constitution shall continue to hold the office in terms of this Constitution, subject to consistency and conformity. It doesn't operate here.
It doesn't operate here.
And
Yes.
any amendment or repeal. Now that amendment is the Act of Parliament that we talked about.
Yes.
So I'm saying, according to your submission, you are saying that as matters stand now, your client falls under 163. You are saying he should not be touched.
Yes. It falls under 143B.
Read with 163.
Read with 163. Yes.
Therefore, he cannot be recalled.
Therefore, he cannot be recalled. That's our submission.
Pending the enactment of.
Pending during the window period of 18 months.
Yes.
Pending the enactment of an act of Parliament.
Yes.
Yes. And what happens after the act has been enacted is something else.
The office that he is holding, is it established by the Constitution?
It's his counsel. I suspect it appears in the
regulation.
In the Public Service Act. Let me check, my lord. I know it. I know the Public Service Act sets out the categories in foreign service. Is it the regulations? Yes.
No, it's the regulations.
It's the regulations. You're correct.
2008.
Yes, my lord. Is the regulations? That would be regulation. If it's what you could bear with me.
Maybe 163 would assist. 163.2. Because 163.1, the way I understand it, it refers to constitutional officers.
Yes. Can I read it, my lord?
So are you reading?
I'm setting out the officers that have been. I'm reading it from the regulations, my lord. That would be Regulation 103,
Yeah.
and it says the following. The posts in diplomatic missions shall be as follows. The High Commission, Ambassador or Permanent Representative, Deputy High Commissioner or Deputy Ambassador, Minister, Councillor, Councillor, which is where my client is.
So in other words, you are saying that your client falls under existing offices.
Yeah, it falls under existing.
But those cannot be 163.1 offices. It should be 163.2 offices, isn't it?
It should be, yes. It cannot be 163.1. These are different offices.
Because 163.2 says under the Constitution or any existing law. In other words, the law that exists.
Yes.
So you are saying your client is covered by 163.2.
Yes.
So he cannot, he should not be required to vacate office.
Yes, madam.
No, he has 6 months within it to vacate.
Yes.
Unless, of course, he chooses to retire
Or
to
continue to serve
in another capacity.
in another office. And they have to be read together. Yes, I agree, madam.
So you're saying that's where your client falls?
That's where my client falls. And because he's established by existing legislation. And the existing legislation is Regulation 103, as 103 D, as I read it to his lordship.
Okay.
Yes, ma'am. And we therefore, my lord, submit that the applicant has made out a case for agency in the particular circumstances. And this is a matter that raises very public interest issues, my lord, and which will be more clearer when we deal with the merits of the matter, and I hope we will do so.
I don't want to go to the merits now.
No, I'm not going to the merits now.
I just wanted to test agents.
Yes.
So you're saying he shouldn't come back from India?
He shouldn't come back
pending
finalization of the matter and pronouncement of the matter. I'm adding this, that the matter is of public interest, my lord, simply to demonstrate that the legal issues that arise, that we have just debated with his lordship, demonstrate that the matter is quite complex. I know we have tried, and his lordship has tried, to make it simpler so that we can debate it in a more simplified and in a more elegant manner. But the point is, the issues that are raised, that the papers have raised, that have been raised by my client, are complex and so interesting that they not only will affect him, but they will also affect.
No, but I'm concerned with him. You are saying he shouldn't come back.
Let me not go further than that.
Live daily for myself.
Exactly.
That's what you are saying.
That's all that we are saying.
On the basis that he's covered under 163.
Yes, ma'am.
Under 163.
Right, with the other provisions.
Regulation.
Yes, ma'am. Thank you.
Yes, Mr. Thakalekoala.
Sorry, my doctor. Now I understand that the matter is a bit complex. We will try to uncomplicate it.
No, we have actually scrambled the egg. We want to unscramble it.
Yes, maybe I would say
The issue is very simple and straightforward.
yes.
You have heard the debate.
Yes.
Yes, Letsika is merely saying my client is covered by 163.2, right, with the regulation. 143 says, with the coming to effect of the 10th Amendment, everything is frozen until Parliament has passed a law. That's all that he said.
Yes. His Lordship has asked my colleague a very pertinent question in this.
So you are no more studying in jurisdiction now.
I'll come to that.
No, but then if you raise, you start with jurisdiction.
Yes, my lord. Maybe I should.
Don't answer the merits. You should tell me, you said this court doesn't have jurisdiction. On what basis are you saying that?
Yes, my lord. Two bases. One, it is preeminently a labor matter. The applicant before you, my lord, is disappointed by what he calls an unlawful decision, unlawful because it is unconstitutional, and all the other bases he's placing on the matter. But what we gather from the facts is that that disappointment arose from a decision declining renewal of his appointment as as consul in India. So essentially, what this is about someone who is aggrieved by the decision renewing a fixed term contract.
When was the decision made?
It was made in April. Let's go to his affidavit, we'll find it.
It was made in April.
Yes, madam. He said this.
Yeah.
Para 1. Para 1 takes us to para 4 and 5. What he says in para 1 is that there was a decision in August reiterating an earlier decision, declining my proposal for a renewal. You will get that in para 4, my lord. Para 4 says, on April 2, I made a proposal for the renewal of my contract, in other words, for the extension. But that was declined on the 21st April 2025. You will see that in para 5. So that decision was made a long time ago. And it is a decision concerning employment, nothing else. Whether that may have implications on constitutional issues is something else.
Yeah.
Now, my lord, as recently as of August, I think, August day 4, this court, in a matter in Matsoso versus the peer.
No, before you go to the Matsoso.
Yes, ma'am.
The applicant on the papers requested an extension twice,
Yes, ma'am.
isn't it?
That's correct.
What did government say?
Still declining.
Where do I find that?
Oh. Page 49, my lord, of the record, Annex A7.
Page 49.
49. The pages are identified, I think, by use of a machine, very complicated machine, but which does work very nice. A7, that's the annex we're looking at.
Yeah, but it's dated 25th August.
Yes, madam. What it does when we
In
read,
other words, government didn't react between 2nd April and 24 September or 24 August.
let me check that, madam.
Now, when you read A7,
Yes, ma'am.
if you are relying on A7, the first paragraph says, reference is made to a letter reference, blah, blah, dated 2nd April 2025, on the above caption subject.
Yes.
That's all that it says.
Yes, I agree. But
So
what
I'm
it does,
saying, he makes a request twice
yes,
to extend,
yes,
and the Crown only answers him last month.
let's look at
Last
this.
month, isn't it?
Let's look at the second request. The date.
Where do I find it?
You'll find that in A6.
Yeah.
This is the letter dated 20 August 2025 by the applicant. The applicant relies on some medical
No,
reason.
but Mr. Thabang, it doesn't answer my question.
I think
I'm
it's
saying he made a request
yes,
way back in April,
yes, ma'am.
isn't it?
And it was answered
When?
on the 21st of April. Paragraph 5. Paragraph 5 of the founding affidavit tells us that. This is the applicant talking to his court. He says, and I read me. On the 21st April, I'm reading from paragraph 5 of the founding affidavit.
Yeah.
On the 21st April 2025, I wrote to the first respondent requesting extension of time by 6 months. I made the request for professional reasons and personal reasons, such as the likelihood of a high tax imposition on my personal effects, namely the vehicles and the like.
I don't know what difference it makes, because I'm saying the discussion was held in April,
Yes, ma'am.
isn't it?
That's correct. And a
Now,
clear decision.
according to A7, you are referring to A7.
Yes,
You
ma'am.
rely on A7. The principal secretary, the heading there is end of term, and he references the date of 2nd April.
Yes, ma'am.
That's what I'm saying. In other words, the principal secretary only reacts last month.
No, now I
You
understand.
understand what I'm saying?
I understand the question now.
Yeah.
Oh, maybe he hasn't annexed the response from the PS previously.
No, the problem is that there are no opposing papers. You cannot tell me about things which are not on.
But we are looking at these papers.
Yes.
Yes.
So we go by the record now. You
Yes.
say maybe the peers omitted. Why do you say it?
No, I'm saying
Because
that.
you are relying on the papers, you are opposing this application
Yes,
on the papers of the applicant.
yes, I'm saying, my lord, and
So I'm saying according to the papers, the peers never reacted. He only reacts last month.
A1, my lord, page 28.
What does it say?
This was the first notification. He writes on
In
the 14th.
April.
Yes,
Yeah, and the applicant answers that in paragraphs 4 and 5
yes.
of the founding papers.
Let's
I
go
don't
to-
understand what you are getting.
Let's go to A3.
Yes.
Let's look at the date, 14th August. That's the request. That's the request.
Yes, Thakalekoala, I'm not talking about the request.
So,
I'm
madam-
saying the applicant repeated the request, isn't it?
No,
Why do you say that?
let me clarify this, madam.
You can't say no, read the annexures.
Yes, I'm looking
But
at
then you
page
can't
3.
say no because the annexure says yes.
My lord,
So you can't say no when the annexure says yes.
the request at A3, page 31, dated 14th August, answers the question. It says, my lord, this is the applicant requesting for an extension. This is in August 2025. And in August 2025, the response is clearly given to the applicant declining.
But he references the correspondence of 2nd April.
Yes.
That's what I'm saying.
And
In August, the PS talks about the correspondence of April. That's what I'm saying. So the PS didn't address the matter
yes,
between April 2nd and 24th April.
yes, my lord. We'll go there, my lord, later. But it may be a question
Now,
now.
I can't go there later, go now. Because I don't follow your argument, Mr. Albert.
Yes.
The point is that this applicant made 2 requests. You understand? You haven't read the papers, that's why you are reading them now.
No, my lord. Where I'm standing and from where I've read, the request was made.
No, you haven't understood the papers. Maybe you should argue your point of jurisdiction.
My lord, I think.
Because that's the one that perhaps you can argue. But the papers, I don't think you follow them.
Yes.
Because the problem that we are having here is always the crowd, public servants, decision makers in the public service, who don't react timelessly to what people want. They go to sleep. And I'm saying on the papers, it appears the peers went to sleep.
Well, my lord.
The applicant talks to him in April, he goes to sleep. He wakes up only last month.
I think that's why my lord is not hearing you.
I hear you,
Yes,
but
sir.
you don't understand me. Your problem is that I hear you, you don't understand me.
Let me make his lordship hear me on this one.
I hear you.
Yes. I'm
And I
saying,
can only go by the papers, by not what you are speculating.
okay. Yes.
And
my
I'm saying, on the papers, it's very clear that the applicant writes to the peers in April,
Yes. My lord.
isn't it?
Yes. My lord.
Asking for extension.
Yes.
Twice. The PS only answers it in August.
Here's the
He says,
issue.
no, look, man, we're already recruiting someone else. Come home.
That's why, my
But
lord.
the poor fellow said, look, I have the following. I'm undergoing treatment. I'm sickly. There's all this stuff. Can you extend, please? Apparently he says, I don't care, even if you are sick. Come home.
Maybe he said he would come to Sankatan.
Yeah?
Maybe he said, no,
He didn't say that. He went to sleep.
Yes, my lord, but
I'm saying on the papers, he slept on the job.
if I'm reading the
Now, if someone is sickly, is it not a reasonable request? These people are overseas. They access the best medical facilities. They say, please, I'm sickly. Yeah? You don't say you should come home and die.
But my lord,
Or you keep quiet so that he dies. You don't do that. It's a reasonable request to say, okay, can you extend? I'm in this predicament.
yes, my lord.
Now the PS decides to sleep.
I hear his lordship. I hear you very well. But my lord, that question, it may be a question of the merits. Did their PS apply his mind to this reasonable request?
You are
But
the
we are not
one
there
who
yet.
went to the merits. Now when I go to the merits, you say that's a question for the merits. That's why I said to you, maybe you should talk about jurisdiction.
Thank you, my lord.
If you are confused,
I'm not
bear
confused.
with you. Now, just talk about jurisdiction. You are saying,
I'm saying, my lord.
according to the Labor Act 2024,
Yes, a matter.
this is an employer-employee relationship.
That's the whole point I'm making.
Who's the employer?
The employer is the government of Lesotho.
Who precisely?
Sorry, my lord. The
Who
whole
precisely? When you say government of Lesotho, there are so many ministries. There are so many functionaries. I want to know.
It is clear the first respondent, who's the chief accounting officer, is the chief accounting officer of the Ministry of Foreign Affairs and International Relations. That's the
Is he
employer.
the employer?
That's the employer, my lord.
So a public servant employs another public servant.
Sorry, my lord.
A public servant employs another public servant.
The commission, that's the third respondent.
No, you said the PS. I asked, you said no, it is the PS. That's why I asked. Now you are saying the commission.
No, the PS is the facilitator, of course.
So why did you talk about it?
Yeah, maybe it was a slip of a tongue.
This town shouldn't sleep many times.
I understand.
You shouldn't.
I understand, my lord.
You have water. Maybe you need water. You don't have water.
Why, my lord? Am I not making sense?
No, the time is sleeping too.
I thought it slept once.
So I'm saying to you, Mr. Thakalekoala, if the appointing authority is the Public Service Commission,
Yes, ma'am.
the PS relates to them only in a supervisory capacity,
That's correct, ma'am.
isn't it?
I agree.
He can even discipline them.
Yes, ma'am.
But this 10th Amendment says that power now vests in the Prime Minister.
Yes, ma'am.
What is going to happen?
Yes, which is a question now in the merits. But let me answer.
No, on the law now, on the law. We are talking about jurisdiction. I want to understand.
Yes.
Because this amendment has now superimposed the powers of the Prime Minister
Yes.
over the powers of the PS.
The applicant is here because he's saying, you public functionaries identified in this have misbehaved in a sense that you have not adhered to the constitutional demands, in fact, the provisions in section 143B and 163.
So for his course of action, he relies on the Constitution.
Yes.
The 10th Amendment.
Yes, Lord.
Yes.
But he's not.
Can the labor court interpret the Constitution?
Yes, my lord.
In terms of which law?
In terms of, I would say there are two constitutions now as
No, I'm saying the labor court. I'm talking about the labor court.
Yes, ma'am.
It's a court subordinate to this court.
Yes, ma'am.
Can it interpret the Constitution?
I think that's not where the request is in terms of the prayers.
Answer my question. Can the labor court interpret the Constitution?
Yes, in a matter that is sitting before you.
In terms of which law?
In terms of
You don't know which law.
no, I know, my lord. In terms of
Don't guess.
I'm not guessing, I have the Constitution here.
Which section of the Constitution? I've read that Constitution many times. Since 93. Many times since 93. I've read the Labour Act of 2024.
Yes, ma'am.
I
In
don't
terms of
find anywhere
Yes.
where the Labour Act itself, which creates the Labour Court.
yes,
The
ma'am.
Labour Court is created by, not by the Constitution, by Parliament.
Yes,
It's Parliament in that Act which creates the Labour Court, say the Labour Court has constitutional jurisdiction.
what I gather from the Labour Act, my lord, is that in a matter which may be brought to, before a Labour Court because of the decreed powers to the Labour Court, and even that if that matter implicates constitutional rights, that court has jurisdiction to decide on that, unless that court can.
Where do you find that? Where in the Act? Read the Act. The Constitution won't assist you because the Labour Court is a creature of statute.
I understand.
Yeah.
But my lord,
Why don't you want to go to the Labour? You have the Labour Act. Why don't you read it? Just tell me, no, in terms of section so and so.
no, all I know is that in terms of section 51 and in terms of section 43, the Labour Court will have a jurisdiction over a labour matter. And if in a labour matter there arises a constitutional question, it can refer in terms of section 158, sub 1, if it is so persuaded to refer a matter.
But you understand that Mr. Letsika has come to this court to interpret the Constitution.
No, my lord, I'm looking at it.
He says, I'm relying on 143. B. He
Yes.
says, that's my cause of action, I'm relying there. Why should he go to the Labour Court?
Yes, same as Mrs. Matsoso. When she came in, she relied in section 119, sub 1.
Wrongly.
As wrongly as the applicant.
No,
is.
wrongly.
Yes.
Yes, she was wrong.
And the same thing.
And I said so, and you are happy when I said
I'll still be happy.
so actually, you are
I'll
happy
still
when
be
I
happy.
said so. So I'm saying, and I said so because the Court of Appeal, in a plethora of judgment, said so.
Yes.
So I was not innovating, I was merely saying, this is what the Court of Appeal has said, Mrs. Matsuso.
And my submission is simply.
So I'm saying here, Mr. Letsika says, I'm relying on the 10th Amendment
All right, my lord.
for my case. He's merely saying that. And he's saying, if you read that amendment, it has frozen, it has created rather, a career public foreign service. And according to the regulations, 103 of 2008,
Yes.
Mr. Letsika says, my client's office is specifically mentioned there. Therefore, reading the law as referenced in the 10th Amendment. Do you have the 10th Amendment?
I had.
Read it.
Which section, my lord? Which part? I think he relied on paragraph 28.
Read section 28, 163.
2. Any person who under this constitution or any existing law would have been required to vacate his or her office at the expiration of any period shall within a period of 6 months of the coming into operation of this constitution vacate his or her office and may choose either to retire
No, you can
or to
blah, blah,
continue.
blah.
But let's go to sub 4.
No, don't go to sub 4. Tell me what has reference to any existing law.
The existing framework, like the regulations that he has.
In other words, you agree
I
that
agree.
the regulations apply.
I agree. But let's go to sub
If
4.
you agree that they apply,
Yeah.
this constitution, second constitution of 10th Amendment, you can
Yes.
call it that way, says any person who under any existing law, in other words, under the regulations, would have been required to vacate his office at the expiration of any period, that he would be required to vacate because his contract came to an end.
Yes.
Now he says that person shall within a period of 6 months on the coming into operation of this constitution, vacate. So the 10th Amendment gives Mr. Letsika's client, as I understand it, a period of 6 months within which to vacate at the end of his contract.
In other words, it gives him a list of a new contract in some sense.
No, there's no new contract. It's the Constitution that says that. The Constitution says if you are in that office under an existing law and you be required to vacate, vacate also means recall, isn't it?
Yes, my lord.
If once you consider that vacate includes recall, it means that he cannot be recalled. He has a 6 months period in terms of this amendment of the Constitution, within which now to vacate. So you have to wait for 6 months.
Yes, the problem is the use of the word recall. Because now that's a mischaracterization. Because, my lord, he's been notified that his contract has, by the terms agreed in August 2022, come to an end.
Then 163 says, wait for 6 months, give him 6 months.
And
that's what it is saying. It says, okay, if his contract is ending, he has another 6 months. That's what the Constitution says. And that's the case of the case that Mr. Letsika is arguing.
I understand.
He's merely saying, look, in terms of this Constitution now, although he's not even contesting that his client's contract is not coming to an end. He says it shall come to an end, but I have 6 months to go after the termination of the contract, after the expiration of the contract, not termination. Now, what the Crown is doing, instead of waiting for that 6 months, they are now saying we are terminating. Come on. This Constitution says no, you cannot do that. That is 163(2).
Yes, ma'am, but let's look at the sequence. This happened in April.
Yes.
And in a matter almost similar by the application of the law which was applied by this court in the Home Affairs ex-workers versus the PS Home Affairs and others, 2021, a decision penned by yourself, the Chief Justice, concurred to by His Lordship Napati and Mafili J. You said in that court, in that matter, that a fixed term contract which comes to an end by fraction of time cannot create any further obligations on the employer.
I agree, but this Constitution now says no, give him 6 months.
Yes.
This is what the Constitution, and this Constitution was not in place then.
Yes.
When that matter came before me.
But if I were
so you can't rely on a case, on authority,
yes,
which doesn't speak to the law that is being pleaded. The applicant is pleading the Constitution.
Yes.
He says, when you read this Constitution, under 163(2), I'm relying on a law. And this Constitution says, if there's a law that regulates expiration of your contract, you see, that expiration, when it comes to an end, you have an additional 6 months.
I understand. Let me try to come with it.
If you understand, then what is the problem?
Because yes, I think we have to interpret the provisions of this Constitution. This amendment.
Mr. Thakalekoala, I'm still talking about jurisdiction. What is the problem?
No,
I'm not talking about the merits. I'm saying he has pleaded prima facie. It's a prima facie right, which I have to present.
I understand.
Yes, and imagine if this applicant lives daily for myself, only for his application to succeed on the merits. What is going to happen? And as I understand, he's sickly. He's still saying, look, I'm sickly, I'm still taking a medication here. I'm under the supervision of doctors. Should we risk his life to say, come back, if you win the case, you go back? Should we say that? And then you say he's going to go to Sankatan. To do what?
My Lord, to the extent that His Lordship has explained.
I think you are trivializing the issue here.
No.
We are talking about a sickly person
here. Yes.
Yes, and he says, I'm relying on the Constitution. I have 6 months now.
Yes. But in the Constitution and in this Constitution, the health issue cannot be a ground to forestall what is
No,
said.
Mr. Thakalekoala,
Yes.
that would be an absurd interpretation of the law. If a diplomat felt sick, let's say he has a month to go, or
Yes.
2 weeks to go, he falls sick and is hospitalized. Are you going to say, no, at the end of the expiration of the remaining period of 2 weeks, you are no more a diplomat, you are a private citizen, we are not going to take care of you?
I was not saying that, my lord. But
That's a callous approach.
But let me take you to the pleadings.
Don't take me to the pleadings because you are going to the merits. You said I don't have jurisdiction. That's mainly what I'm inquiring.
Okay, my lord.
Because I'm saying you don't answer Mr. Letsika's predicament. He says, my client is sick. He's sick,
Yes.
as you are talking now. And you haven't rebutted that statement.
Yes.
Yeah.
My
So
lord,
there's medical evidence that is placed before me that this man is very sick.
I understand. But
So don't be callous. Don't call him now. In any event, the Constitution says he has a grace period of 6 months.
my lord, let me not deliberate or takes time on this jurisdictional point. Let me
Then you are
accept.
saying you should go to the labor court.
Let me accept that this court would have the jurisdiction over the matter. Let me accept that.
No, the question is, the issue is very simple, Mr. Thakalekoala.
Yes, my lord.
Does he have a prima facie right which is under threat? With regard to his civil status?
I would say he does not.
Or you don't care whether he's sick or not?
I'm not saying that, but I'll tell you why I say so. When he first made the proposal for the extension of the contract, there was no issue concerning his medical condition. And when he said so in April 2025, he had already been in hospital, having operated 2 months prior. That was in February
And
2025.
the peers was aware.
But that's what he told the peers.
And the peers, yes, the peers became aware.
Yes.
What did the peers do?
Now, the peer says, no, we will not be renewing. We will not be renewing.
That's what I'm
because-
saying, the peers is being callous. He doesn't deny that the man is sick. He says, well, although you are sick, you will die in India if you have to, because you are not going to renew. Is that how you treat citizens in a democratic state?
No, my lord.
Power has to be exercised humanely. You
Yes.
don't just say, because I have power, you go to hell. That's not how a democracy functions. That's why I say these peers went to sleep.
My lord,
If this person says, I'm sick, give me an extension, the peers doesn't reply. He makes another request. He only replies in August.
No. I think I'll get back to that point again. Let's go to
No, I'm not going to go back there.
Yes, my lord.
Because your only point is jurisdiction. Once you concede that this court has jurisdiction, then the case has been made for agency. I don't see how this court would not intervene when someone tells me, I'm sick, I'm undergoing medical treatment, then I say, come home, you go to Sankatala.
Am I not, my lord, now going to address why the interim relief, the interdict, may not be tenable?
It's agency. I thought you considered that this man has a prima facie right.
I didn't say so.
Are you saying his sickness is not in jeopardy?
Yes, my lord.
Why?
It is not.
Why?
That's why I was giving you the narration from
Where is there medical evidence to negate that?
Sorry?
You have medical evidence?
It is here. It's his own. I'm going to point to the paragraphs which indicate that his life is not in danger. It is here. He has given it.
What do those paragraphs say?
Yes, my lord. I was at a point where I was...
No, give me the paragraph, not at a point. Tell me which paragraph that you are relying on, not at a point. You said you are going to direct me to paragraphs in his own papers. What are those paragraphs? And what do they say?
Thank you, my lord. I'll do that.
I don't want to prolong this matter, Mr. Thabang.
I understand, my lord. But it is
So in the next 3 minutes, you should wrap up.
It is best that I try what I can do. It is best that I give you at least what I think of the case.
Yeah.
Yes.
I know it's the duty of counsel to make a best of a bad case.
Yes, madam. I was saying in the letter which he wrote, Annex A1, it is referenced in paragraph 4 of the founding affidavit. Dated.
No, dated, you don't have to peruse. Look at the top of the letter.
21 April.
Yeah.
Yes. He makes no mention of the medical problem. Although he was aware that he had gone for a medical procedure.
What is the basis of for the extension?
He's saying the basis. He's
read the letter. Don't tell me. You said you're going to read the paragraph to me. The problem, you haven't read this letter. That's why you are perusing through now pages. You haven't understood what this man is saying.
I think I do. A2.
You haven't understood what this man is saying.
A2, my lord. It's found at page 29 of the record.
What does it say?
It says he wants to continue because he has some interest in bringing investors in Lesotho.
Yeah.
Post his termination.
Yeah.
Or post his end of tour of duty.
Yeah. And when was the 12th duty? When was it due?
15th August, 15th September 2025.
Yeah, so he actually writes timelessly.
Yes. And what is the reason? I want to do what I failed to do yesterday. That is the reason.
No, that's not the reason.
I will read. The second reason.
Under oath, paragraph 5 is very clear what is the reason. It's not what you are thinking about.
I'm reading the letter dated April 25. April 21st.
That's what I'm saying. He talks about that letter in paragraph 5 of the founding affidavit.
Yes, madam.
Yes, and it's clear what he's saying.
The only reason he has annexed it is he wants us to look at it. And I'm looking at it, it is...
Or you are not going to look at paragraph 5 of his affidavit?
No, my lord, I have... He says...
he tells me under paragraph 5 of the founding affidavit the reasons for the extension.
Professional and personal.
Yeah.
Now let's look at the professionals. The professional reasons are outlined in page 39.
Then under paragraph 6 of the founding affidavit.
Yes.
Then he gives a reason why he wants an extension.
Yes.
And by then, this contract had not expired.
I understand.
Yeah.
But
so what is wrong with him now saying in August that I'm sick now, I'm hospitalized, critically sick, I want an extension?
No, he's not saying he's hospitalized.
He's critically sick.
No, let's look at the letter that he has annexed. That letter, my lord, at page 48. That's the letter from Apollo. Infrastructure Apollo Hospital. It says, to whom it may concern, let's look at the date. It is 16 August 2025. And these doctors are telling you, your Lord, that we have been seen to the health of this person. This is our patient from 2023. Let's tell you that in February, he underwent a medical procedure. Now, we want him to stay here because we want to have a look at him till 2026. But that letter is dated 16 August 2024. But let's go back a bit again, Melo.
No, I'm not going back a bit again. I don't understand why you will select him.
I'm not.
Under paragraph 6.2, it's very clear what he said.
Yes.
What his physician says.
Yes.
Yeah.
And these physicians say, we have been monitoring him from 2023. We want to monitor him to February 2026.
Yeah.
Yes, and now this is
What's wrong with that?
There's nothing wrong. But
If he is right, then that's the only reason why then the peers should extend this contract.
look at the date, 16 August 2024. Let's look at what he writes to the peers.
The peers hasn't queried that.
Sorry, Menor.
The peers hasn't queried that. What's your problem? The peers has engaged this man on written letters. He has never raised what you are raising. You want to read into the letters of the peers something that he never raised. Because your problem is very simple, Mr. Thakalekoala.
Yes,
you are in denial that this man is sin.
I'm giving
Or
you,
you don't care that he's sin.
I'm giving you what is
And the peers doesn't care whether he's sin.
My Lord.
Now this court should endorse that color's attitude.
My Lord, if you look at A3,
You go to the merits and you'll oppose this on the merits. But I'm granting this application.
That's okay.
There's a prima facie right here. This man's health is at risk. I don't want him to die. He's in my court.
I understand.
I don't want him to die. So that next when I'm judged by God, God would say, but my person died before you. You are going to die also. I don't want that case.
what prayers are you giving, my Lord?
I'm saying the matter is urgent.
Okay.
Yes, and then I'm going to tell you exactly what I'm saying.
Let's talk about this.
Ms. Letsika, which paragraph of the order?
What
In the interim.
in the interim, it will be prayers, and I'm on page, if you all should bear with me for a second. I'm on page 12, page 13 of the record. That would be prayer 1, which is dispensation. And then it will be prayers 2.1, 2.2, and 2.3, my Lord.
2.2.
That would be, let me recount, my Lord. We have set them on page 14, paragraph 16. That would be prayers, I'm sorry, my Lord. Prayers 1, 2.1, 2.2, 2.3, and 2.4, my Lord.
2.3, 2.4.
Yes, my Lord.
And 2.4 is just maintenance of the status quo, Mr. Letsika.
Yes, my Lord. It's we might as well. It's superfluous.
Once the rule NASA is granted,
It
in terms of
it covers 2.4.
prayers 1, 2.1, 2.3, 2.2, 2.3.
Yes, ma'am. It covers 4.
Yeah.
So, my Lord, I'll not persist in. I'll not persuade His Lordship on 2.4. I'll say 1, 2.1, 2.2, and 2.3, my Lord. That should suffice for our purposes.
Prayers 1 to 2.3. Yeah.
Yes, ma'am.
Then what's the return date? Or even before I go there, now that I should give you the roadmap.
Yes, ma'am. I was going to suggest.
Once the prayers are, the interim relief is granted.
Yes, ma'am.
In terms of the prayers that you pray.
Yes, ma'am. In other words, we'll no longer utilize Rule 64.
So,
I'm saying we'll no longer utilize the provisions of Rule 64. It applies when the matter is not urgent.
yes.
Well, I'm saying 64, my learned friend says 65. I'm talking about a different rule, which talks about case planning and all that.
No, I'm not going to plan anything here.
Yes.
What I want you to do is they should file their heads.
I mean, the answer in papers, we file our reply, and then together with our heads possible. Yeah.
You are only here in November. Because I'm not available in
in October. And we are in the Court of Appeal, my lord. I know I have about 5 or 6 appeals.
That's where I am.
Yes, my lord.
I can only see you in November. But we have to now
Set out the roadmap.
Yeah.
Yes.
So the respondent, those are the additional paragraphs of the order.
Yes, ma'am. I'll put them in the order.
So the respondents must file their opposing papers, if any. Two weeks, Mr. Galpa.
2 weeks will be fine, my lord.
What will be the date? 2 weeks hence. I want 10 days
Let me check my lord.
after next Monday.
It will be
It takes us to the 10th.
to the 10th.
Yes.
By or not before? Or not before? Is it?
Yes, my lord.
Or not before the 10th?
October.
That's when the Crown should file their opposing papers.
And all have
Then the applicants must file
by the 17th.
their reply, if any, or not before 17th.
Yes, ma'am.
And then the applicant to file his 2 weeks from that, Mr. Chief.
Yes, ma'am.
What will be the date?
That would be the 24th.
By 24th of October.
Of October, my lord.
And then the
I'm advised, my lord, it's 1 week. I think I'll need about 2 weeks, my lord, with your permission, so that I make truthful submission. Can I propose the 31st of October, my lord?
31 October.
Yes, my lord.
Mr. Thakalekoala, you are his?
The 10th, my lord.
November.
10th November, my lord.
And then matter to be argued on
November 18th.
no. This one is of my own choosing.
Yes.
It's not council.
That's the court decision.
I'm the one who decided when to do it.
Oh, sadistic.
Then the matter will be argued on 24th of November.
24 November, my lord.
In the morning, my lord.
Immediately, I'll be in the agent court, I'll be here. As soon as you are done with the business, then you start arguing.
As the court.
As the court pleases.
So the order then, to recap, having had counsel and read papers, the matter is agent, and the following prayers are granted. Then it will be prayer 1 to 2.3, isn't it?
Yes, my lord.
And then the additional prayers will be the respondents must file the opposing papers, if any, by or before 10 October 2025. The applicant must file their heads if any. No, they are replied.
They are replying.
If any on or before 17th of October 2025. The applicant to file heads of argument by 31st October 2025. Respondents to file heads by the 10th of November 2025. The matter will be argued on the 24th of November 2025.
As the court pleases.
So type it, Mr. Letsika, the order,
We will do so.
so that I can sign it and then file it on record.
As the court pleases.
As the court pleases.